So my name is Katina Pantazis. I am an elder law attorney in the Villages. And I'm going to talk to you today about what to watch out for with elder law attorneys or attorneys in general for your clients in this area. So first of all, what's elder law? What's an elder law attorney? We handle estate planning, which is creating documents like wills, trusts, advance directives, power of attorney documents. We do probate, which is administering your estate when you pass away. And we do trust administration, which is administering your trust when you pass away. We also do long-term care planning, which is Medicaid planning, and also VA planning. So some things that you should look for in an elder law attorney. You want to make sure, first of all, that the elder law attorney is licensed. The state of Florida licenses attorneys, just like any other state. And you want to make sure there aren't any complaints. You can check all of this on the Florida Bar website to check out the attorney. You also want to make sure that there aren't any conflicts of interest, or if there are, that you're made fully aware of them and that you've waived that conflict. So what I mean by that is attorneys nowadays, sometimes they also sell financial products, they sell insurance products, and they may be using their legal expertise to pull you in the door in order to sell you those other products. Now, it's perfectly legal and fine to do that. However, they need to make sure, and you need to make sure, that your clients are aware of this conflict of interest between the legal representation and the selling of financial products. Okay, so what to watch out for in a law firm? There are firms out there that are just going to produce plug and chug documents, meaning they insert information into documents that are already pre-made up and have nothing specific to you, your family, or your situation in a state. There's a lot of harm in that type of document because it's not specific to you. So, you know, you could be treating children the same, beneficiaries the same, which could disqualify them from certain benefits that they're receiving, or maybe you don't want to treat them the same and you want to only have a certain percentage going to a child, or you don't want anything going to a child or a beneficiary. So remember, cheapest isn't always the best, because filling in the blanks a lot of times can be more harmful to you than actually helping you in the end, because your family ends up paying for that. The initial consult with an attorney needs to be with just the attorney. So a lot of times people want to bring in their family or their friends or their advocate with them. That's okay for that person to wait in the lobby, but you have to meet, or the client has to meet specifically with the attorney in order to preserve the attorney-client privilege. The moment we bring in a third party to that consult, the attorney-client privilege is destroyed, meaning what we say is no longer private, and we can be subpoenaed to provide that information if ever sued. Also, in the execution of documents, we want to make sure that it's only the attorney, the client, the witnesses, and the notary. If a third party comes in there, or an additional party comes in there, you've again destroyed what you're trying to create, which is signing a legal document validly in the state of Florida. The reason I bring that up is I've heard horror stories of other people included in a signing or in an initial consult. So if there's ever litigation, you've now created a huge issue that has to be addressed by the court. Okay, so online do-it-yourself documents are just as harmful as the plug-and-chug documents of the document prep firms. The online do-it-yourself documents are like LegalZoom, or you know, if you went to FedEx or Office Depot. If you're buying a package and inserting information to it, you're altering that form. So the moment you alter it, whether you add information or take information out, you're changing the meaning of that document. And if you don't have the knowledge of how you're changing it and what that means, you could be creating a lot of harm for your family. So yes, it may be $50 at Office Depot, but when you pass away, your family is going to end up having to pay an attorney a lot more money to fix the mistakes that you have made by creating your own documents. It's the same as, cookie cutter documents by law firms. You want to make sure that it's specific to you. The attorney has sat down with you and has figured out your specific wishes, what your family makeup is like, and how you want to distribute your estate, who you want in charge. So consider that, make sure that it's not always the cheapest. All right, out-of-state documents. So I get questions all the time, do I update out-of-state documents? The answer is maybe, and it depends. And I know that sounds very attorney-like, but you want to see an attorney in the state that you reside in order to know if your documents are correct and up to date and sufficient for that state. Each state has different requirements. I do have documentation pamphlet that I can send you that what we look for in Florida for documents. There are certain requirements that we look for to make sure that we can submit it to the court and that it's valid once that document has been submitted. So regardless, a consult with an attorney in the state that you live in would be sufficient to make sure that your documents are up to date. Alright, let me go back one. So another question I get a lot of times too is, what are the documents that I need in Florida? Well, here's a list of some of the documents that we typically require our clients have. And what they are is a power of attorney. So you need to have a document for your financials in order to have somebody in charge of making financial decisions for you. A healthcare surrogate, a document in charge of naming someone to make healthcare decisions for you. A living will, which is the document at end of life that allows for someone to pull the plug because you've made the decision today while you have capacity of what you want to happen should you ever be in that situation. A pre-need guardian, if you ever need a guardian, meaning if somebody's trying to come in and take over control of your estate or your health care, you've got a document that states, well, this is who I want in control. A will, a trust. Do you need both? Do you need one or the other? That really depends on you, the situation, your family, how you want to leave your estate. And then potentially disposition of bodily remains. So if your family is in disagreement of how your bodily remains should be handled, you want to have a document that states who is going to get your bodily remains so that your wishes will be completed when you pass away. So, one of the last things I want to go over is the emphasis on team. When you are dealing with an attorney, you want to make sure that that attorney has every professional in your life on the same page, because your estate plan is much more than just your legal documents. It's your financial plan. It's your your health plan. It's making sure your family's on the same page as you. It's what insurance you have. It's a ton of different pieces to the puzzle that need to be all fit together in order to make it seamless and a good fit for you. So you want to make sure that the attorney that you work with or that your clients work with is a team player, and that they're okay with conference calls and setting up those meetings. And then lastly, as an attorney, I do have to tell you that this was just informational. And if you want to have a consult with an attorney to see what your specific situation would entail, please do so. But do not take this as legal advice. Thank you.